How does a strange smell coming from a bus locker end up at the Supreme Court of Canada? It sounds like the start of a bad joke, right? But it's actually the true story behind a landmark decision that completely redefined our right to privacy in this country. Okay, let's get into it.
Our story starts in a place that's probably super familiar to a lot of you, a bus depot. To be specific, the one in Winnipeg, Manitoba. It's just a normal day, people coming and going, the usual buzz of activity. But one of those lockers, well, it's about to become the star of an incredible legal drama.
So, here's the play-by-play of what went down. On March 14, 1998, a guy named Mervyn Buhay rents locker number 135. Just about an hour later, security guards notice a pretty strong smell of marijuana coming from it. They get a Greyhound agent to use a master key to open it up, and yep, inside they find a duffel bag full of weed. So they lock it back up and call the police. When the officers show up, they have the locker opened again, and they seize the drugs, all without getting a warrant. The very next day, Buhay is arrested. Seems like a pretty open and shut case, doesn't it? Well, not quite.
And this, right here, is the absolute key. The huge legal fight that followed wasn't really about the marijuana. It was all about how that evidence was found. This case forced the courts to ask some really fundamental questions about our rights as Canadians.
So, the first giant question was all about privacy. You know, when you pay a couple of bucks to rent a locker at a bus station for 24 hours, what exactly are you buying? Are you just renting the physical box? Or are you also renting the right to privacy that comes with it?
This all comes down to a really important legal concept called a reasonable expectation of privacy. This is the test our courts use to decide if the government, like the police, has to respect your privacy in a certain situation. And the key word there is reasonable. It's not about what you personally expect, but what an average, reasonable person in society would expect.
And this is exactly where the two sides went head-to-head. On one side, Buhay's lawyers argued, look, he paid for exclusive use of that locker, he had the only key, it was his private space, kind of like a hotel room. But the Crown's argument was, hold on, it's the bus company's property. They have a master key, so you can't really expect it to be totally private. So who's right?
Well, the Supreme Court of Canada came down squarely on Buhay's side, and their reasoning was so powerful and clear. They basically said, yeah, a reasonable person would absolutely expect their stuff to be left alone if they've paid to lock it up. The fact that a master key exists doesn't just cancel out that right. So point one goes to Buhay.
But that brings us to the next layer of this whole thing, and it's even trickier. Remember, there were actually two searches here. The first one by the private security guards, and the second one by the police. So the court had to ask, did that first search basically give the police a green light to just waltz in and do their own?
And this gets to a super critical legal distinction. In Canada, our Charter of Rights is there to protect us from the government, from the state. The security guards, they were private employees, so the Charter doesn't apply to what they did. But the police, oh, they are absolutely agents of the state, and everything they do is subject to the Charter. They can't just piggyback on what a private citizen finds.
So the court found that when the police ordered that locker to be opened, they were conducting their own distinct search. And since they didn't have a warrant, that search is automatically considered unreasonable under Canadian law. Bottom line, the police violated Buhay's charter rights.
And this is what really bothered the court. Just look at the officers' own words from their testimony. One of them admitted that the thought of getting a warrant never crossed his mind. The other said he didn't think Buhay even had privacy rights. And get this, he also didn't think he had enough evidence to get a warrant anyway. This just screamed a casual and blatant disregard for the rules.
Okay, so the police broke the rules. They messed up. But what happens now? They still found the drugs, didn't they? This leads us to the most dramatic question in the whole case. Should the court just ignore perfectly good evidence of a crime just because it was found illegally?
This is where Section 24(2) of the Charter enters the picture. It's an incredibly powerful tool that says a court can throw evidence out if using it would damage the reputation of the entire justice system. It's not about letting someone off on a technicality, it's about making sure the system itself maintains its integrity.
So, to make this decision, the court has a three-step test. First, they ask, would using the evidence make the trial itself unfair? Second, just how serious was the police misconduct? And third, what would be the overall effect on the justice system if we throw out the evidence?
All right, let's walk through it. First up, trial fairness. The court said the drugs were non-conscriptive, which is just a fancy way of saying they already existed. Buhay wasn't forced by the state to create them. So,
Using the evidence wouldn't really make the trial unfair. But that brings us to step 2, the seriousness of the breach. And on this point, the court did not hold back. They found the police conduct to be a casual and blatant disregard for the law. This was a very serious breach.
In fact, the Supreme Court pointed right back to the original trial judge's concern. He worried that if they allowed this evidence in, it might just encourage police to keep taking this casual approach in the future, thinking they could get away with it.
So this brings us to the final step, the big balancing act. The court had 2 choices. Option 1, admit the evidence, get the conviction, but risk looking like they're okay with police ignoring people's rights. Or Option 2, exclude the evidence, lose this one conviction, but send a really strong message that charter rights have to be taken seriously.
And the final verdict? The Supreme Court decided that the long-term damage of turning a blind eye to the police's actions was far worse than the short-term benefit of getting one conviction. They ruled that admitting the evidence would bring the administration of justice into disrepute. The evidence was thrown out, and Mervyn Buhay's acquittal was restored. He walked free.
So why are we talking about a case from over 2 decades ago about a smelly bus locker? Because its impact stretches way, way beyond that Winnipeg bus depot. It established principles that are actually more relevant today than ever, especially in our digital world.
So let's boil it down. Here are the key takeaways. First, police can't use a search by a private party, like a security guard or even your internet provider, as a loophole to do their own search without a warrant. Second, your right to privacy follows you into places you rent and secure. And finally, our courts have made it clear they will throw out crucial evidence if it means holding the state accountable for its actions. These ideas are now fundamental in protecting our privacy, whether we're talking about a physical locker or a digital one up in the cloud.
Ultimately, the case of the smelly bus locker leaves us with a question that we are still wrestling with every single day. In an age of increasing surveillance and real security threats, where exactly do we draw that incredibly fine line between keeping everyone safe and protecting our fundamental right to simply be left alone?